Okay, please, dear friends, we are going to start. So we are already 15 minutes late, but that's understandable in the morning, despite our strategy, which was to avoid to serve coffee so that people would arrive on time. But I saw that some of you managed, nevertheless, to find a coffee cup, which is understandable. So we start this first session this morning, actually about internal border controls, and of course we are going to discuss the famous case NW. I don't go further. I leave the chair to Mrs. Corinna Ullrich, who is head of unit of the Schengen and External Borders unit in the Commission, DG Home Affairs. So that's, of course, the right person for this session. And thanks a lot, Mrs. Ullrich, for accepting to come here and to give us some of your time.
Thank you very much, Professor De Bruyke. Good morning, and good morning, everyone. It's very early, but of course, border controls are an exciting subject, so I hope we are going to wake you up with our session here. I welcome to my right Stefan Salomon, who is Assistant Professor for European Law at the University of Amsterdam and is going to give us an introductory statement about the issue of internal border controls versus police controls in the territory. To my left, I have Mr. Sorwansgaard, who is the former Advocate General at the Court of Justice, who dealt with the famous case that was dealt with last year and led to the judgment in April 2022. And he comes before serving at the court. He filled several positions in the Danish judiciary and in the Ministry of Justice. So he is a long-standing expert of European law in that area. I'm supposed to have on my further right, Pierre Regnault de la Motte, who I think hasn't arrived yet, but probably he will join us somewhere in the middle. And given that he is the head of Justice and Home Affairs in the French permanent representation and managed last year the French presidency that in the council then led to the general approach on the amendment of the Schengen Border Code that we had proposed in 2021. I guess he will be able to jump right into the subject. So I suggest we start anyway with Stefan, and I pass on the floor. Thank you very much.
Just before Stefan starts, I received a message from Mr. Pierre Regnault de la Motte telling that he is blocked in the European Parliament till 8:50 and will run to here to the conference place and be here within the next minutes.
Thank you so much for this kind introduction, Corinna. I do not have a PowerPoint presentation prepared. There was a famous statement by French military after Colin Powell and the Security Council gave a PowerPoint presentation, and the French military commented it with PowerPoint, c'est du cinéma. So I don't want to bore you with the cinema in this early morning hours. It's hardly exaggerated to say that Schengen is in a profound crisis. The legal and normative core of Schengen, an area without internal border controls, has been seriously undermined over the past 8 years. In 2015, several EU member states reintroduced border controls because of increasing numbers of arrivals of refugees to their territories. And up until this day, 5 member states still maintain these controls. 3 points illustrate this crisis of Schengen, and each point basically shows the difference between pre-2015 and post-2015 practices of reinstating border controls. First, the number of controls rose considerably. In 20 years, from 1995 to 2014, member states reintroduced controls a total of 90 times. This number rose since 2015 to 369 times. This is an increase of more than 600% in a considerably shorter time. Approximately half of the reintroductions of border control since 2015 were because of reasons of irregular migration. This is at least what member states stated in their notifications. Second, the duration of controls increased. Pre-2015, controls were reintroduced for a few hours to a maximum of 4 months. Since 2015, the duration of controls lasted mostly for 6 months, and then after 6 months, they were again prolonged. Third, the perception of what constitutes a threat changed considerably. The Schengen Borders Code, all of you might know, requires the existence of a genuine, present, and sufficiently serious threat that affects one of the fundamental interests of society. Pre-2015, member states reintroduced controls because of concrete events, such as sports events or political summits. Post-2015, a common feature in the notifications that member states sent to the Commission on the reintroduction of border controls is that they all emphasize risks, that is, potential threats, rather than concrete threats. The upshot of these 3 points of these developments is that border controls turned from exceptional, temporary measures into instruments of risk governance, which are employed on a quasi-permanent basis. In principle, the Court of Justice put an end to this practice. In April 2022, the Court of Justice held in its judgment in Landespolizeidirektion Steiermark that unless there is a new threat to internal security, which is different in nature from the previous threat, member states are only permitted to unilaterally reinstate controls for a maximum of 6 months, as the wording of Article 25 in the Schengen Borders Code clearly says. The Court of Justice emphasized thereby that the rules for reintroducing controls are exceptions that must to be interpreted strictly. Likewise, the Court of Justice made clear that member states cannot, if they exhaust this 6 months time limit, simply invoke national security exceptions in primary law, Article 72 of the TFEU, to derogate from their obligations in secondary law in the Schengen Borders Code. The exceptions in the Schengen Borders Code, the Court of Justice made clear, would sufficiently take into account the national security interests of member states. All of this has already been there in previous case law of the Court of Justice. So in a sense, the judgment of the Court of Justice would not really have been necessary to clarify these points. After the Court of Justice, after the Court of Justice gave its decisions, the Austrian Administrative Court, which had referred the case to the court, ruled in July 2022 that the controls maintained by the Austrian Ministry of Interior had been unlawful since November 2017. 6 days before the Court of Justice released its decision, the Austrian Ministry of Interior prolonged controls already for another 6 months. Without any reference in the notification to a new threat. So did France, Germany, Sweden, and Denmark, even though all of these member states are obliged to give full effect to the decision of the Court of Justice. So clearly, Schengen is in a profound crisis. Yet, which crisis exactly is it? I would suggest that in order to grasp which crisis it is, we need to understand a bit the context, the broader context of this crisis. And I suggest that the broader context of this crisis is actually a rule of law crisis and the growing influence of populist politics at the national level. While national governments profess allegiance to the project of the single market, they emphasize the protection of national borders. National borders in this regard assume a key function in a political discourse that seeks to reconstitute national identity. And at the same time, national borders function as a discursive site of protecting against unwanted migration and allegedly dysfunctional external borders. Of course, if we want to look and see how this broader context plays out specifically at the national level, we need to do a fine-grained socio-legal analysis of how the actors, of who are the actors and how these factors specifically function. So for instance, in Germany, the Ministry of Interior or the Ministry of Economy has a different view on internal border controls than the Ministry of Interior. In Denmark, the police was actually against the reintroduction of border controls, thinking that these border controls would not serve the purpose of actually protecting against external threats or threats to internal security. And I think it is this context that shapes the 2 points that I want to focus on in the next few minutes. The legislative reforms of the Schengen Borders Code, and second, the role of actors in implementing the judgment of the Court of Justice. So as to the first point, legislative reforms. Already in 2016, the Commission tabled a proposal for reforming the Schengen Borders Code. Due political deadlock in the Council, the Commission proposals got bogged down. In December 21, the Commission tabled a new proposal. In my reading, the overall objective of the proposal is to, on the one hand, strengthen controls at the external borders and to phase out internal border controls. I think the Commission advances a twofold strategy to how to phase out internal border controls. First, the Commission seeks to reinforce procedural rules when member states unilaterally reintroduce border controls. At the same time, the proposal caters or tries to cater to member states' security interests and concerns, and by providing member states with longer periods of time to maintain controls and with additional grounds on which to introduce controls. This is a tightrope that the Commission tries to walk here with this twofold approach, and I will explain in a second why. Secondly, the proposal encourages the use of alternative measures and police cooperation in place of border controls. The Commission emphasizes in particular selective police checks in border areas and the systematic use of, I quote, monitoring and surveillance technology, unquote, to collect and process data of persons who cross internal borders. For example, the Commission suggests to expand the systematic collection of passenger information data to all intra-EU flights. Arguably, this suggestion will not be limited to flight routes, to air routes, but eventually also apply to land routes, as most of the people do actually travel on land within the Schengen area. After the Court of Justice rendered its decision in Landespolizeidirektion Steiermark, the Council adopted its general position on the Commission proposal, and in December 2022, the Libe Committee issued its draft. So I will spare you the details of both the Council position and the Libe Committee draft, but the Council, I will only compare these two the basics of with each other. So the Council's approach basically reflects overall the Commission's position, but makes procedural safeguards for introducing controls on a unilateral basis stricter. The draft report, on the contrary, of the Libe Committee reduces the room given to member states when reintroducing controls. It removes large-scale unauthorized migration as a ground, as a threat to internal security. It adds stricter temporal limitations for the reintroduction of controls and removes the possibility to reintroduce controls based on a persistent threat, which seems to be more in line with the court's distinction between a new and renewed threat. So, in my reading, the Commission and the Council proposal on the one hand, and the PAL and the Libe Committee draft on the other seem to be based on entirely different logics. An entirely different view of Schengen. The Commission and the Council position essentially reflect an old intergovernmental logic of Schengen. The reintroduction of controls is primarily viewed as a security issue, and the procedures for reinstating controls as a technocratic cooperation between member states and the Commission. The Libe draft, on the other, is based more on a free movement logic of Schengen. The Libe Committee emphasizes democratic accountability and transparency, which assume a central role in the procedures of reinstating controls. The relevant actors are not only the Commission and member states, but via the European Parliament, also EU citizens. It is difficult to say in the current at the current moment on where exactly legislative reforms will fall in this spectrum. Yet it is less difficult to point out the legal difficulties of the twofold strategy to phase out internal border controls. I have 3 points of skepticism on this. First, I'm skeptical that stricter procedural rules will result in stricter compliance. In the past 28 years, member states did not provide adequate reasons for the reintroduction of controls. Although the procedural rules for reintroducing unilaterally controls were made stricter with every single amendment of the Schengen Borders Code. Thus, there is no empirical reason to assume why this would change simply because the rules of the Schengen Borders Code are changed again, especially if there is no political will to enforce these rules. Second, also the increasing use of surveillance technology as alternative measures harbors legal problems. In its decision in Ligue des droits humains, the Court of Justice has wiped the possibility of systematically collecting and processing passenger data for immigration off the table. Although the question in the case concerned Belgian law, the standard of interpretation by the court was EU primary law. This implies that also an amendment of secondary law in this regard would likely to be invalidated. In particular, German judges, with their propensity for data protection, would not be amused at all. And we would expect further legal challenges before domestic courts and references to the Court of Justice. The third point concerns random police checks in the territory. There's ample evidence that non-systematic police checks in border areas are often based on practice of racial profiling. Leaving aside the structural biases that produce these racializing practices, the main problem that I see is that national courts are not yet ready to adequately deal with these issues. National courts in the EU adopt 3 different approaches on how to deal with claims of racial profiling. First, courts explicitly endorse these practices and the logic of racial profiling. In the second approach, national courts duck these questions, mostly on procedural grounds. In the third approach, the whole practice of racial profiling unlawful. The first 2 approaches are the most prevalent in the EU. My point is that when proposing such suggestions to increase the use of non-systematic police checks, this reality should not be ignored. This brings me to my second overall point, the role of actors in implementing the Court of Justice's decisions. There are 2 main actors in this regard, the Commission and national courts. It is well known that the Court of Justice held in the case Landespolizeidirektion Steiermark that the Commission has a legal obligation under Article 27 of the Schengen Borders Code to issue a public opinion on the legality of controls if the Commission has doubts on the legality. Taking these obligations seriously under Article 27 would be necessary, the court emphasized, for a proper functioning of the Schengen Borders Code. The Commission did not issue an opinion until this day. It was only after the Slovenian presidency publicly criticized Austria for prolonging border controls for the 17th time in a row. And the Slovenian government announced that it issues an opinion on the legality of Austrian controls that the Commission recently announced in its Schengen strategy that is ready to take, to quote, to make use of legal means at its disposal, unquote. It remains to be seen how far this goes. I want to point out that this hands-off approach by the Commission basically differs significantly from previous practice. When France maintained controls in 1995 and again in 2011, the Commission did not shy away from publicly criticizing the French practice as being contrary to EU law. What the Commission approach shows is a more general trend of the Commission that prioritizes its role as a motor of integration over its role of guardian of the treaties. The second key actors are national courts. national courts divert in implementing the decision of the Court of Justice. National courts take diverging stances on the implementation of this decision of the Court of Justice. The referring Austrian court implemented the decision of the Court of Justice. Other national courts, however, seem to find ways to work around or outrightly ignore the decision of the Court of Justice. The most infamous example is the French Conseil d'État. Already in 2017 and 2019, the Conseil d'État declared controls compatible with EU law without referring the case to the Court of Justice. After the judgment of the Court of Justice, the Conseil d'État was seized again by 3 NGOs, which challenged the legality of the reintroduction of controls. This time, the Conseil d'État upheld again the legality of controls by the French government. Although the Conseil d'État refers to the Court of Justice's distinction between new and renewed threats in its decision, the only time that the Conseil d'État refers to the Court of Justice's decision, the Conseil d'État adopts its own interpretation of new threats that significantly deviates from the Court of Justice's. A new threat, according to the Conseil d'État, would not only include threats that are different in nature, but also situations in which the scale, intensity, or scope of an event changes. The Conseil then goes on to enumerate several events that would constitute terrorist threats, such as the expansion of terrorist networks in Western Africa or the attack on a prison in Syria with fugitive ISIS combatants. If one follows this reasoning of the Conseil, any event occurring anywhere in the world would constitute a new threat that justifies the reintroduction of border controls. Currently, more cases are pending before national courts. For example, on 8th February 2023, the Swedish Chamber of Commerce lodged an application at the Swedish highest administrative court to review the legality of the government's decision to prolong border controls. And there are at least 2 cases pending before Bavarian administrative courts. So what now? Where to go from here? I have 3 vague thoughts on what the future development of this situation on the reintroduction of border controls could be. And they're really vague ideas. First, the case brought by the Swedish Chamber of Commerce illustrates the possibility of further private enforcement, this time not before administrative courts, but before civil courts invoking state liability. In particular, over the summer months, longer waiting times at national borders, at national border crossing points would likely increase transport costs and negatively affect supply chains. Commuters or transport companies might invoke these damages or damages that result from longer waiting times before national civil courts. Civil judges might have different views on these controls than their administrative law peers. State liability brings us back full circle to the rule of law. We shouldn't forget that the normative origins of state liability lay in strengthening a European rule of law and the protection of individuals against the vagaries of member states who are unwilling to abide by EU law. Second point, the private enforcement of EU law ultimately functions only if it is backed up by public enforcement. This public enforcement could take different forms. It doesn't necessarily have to be formal public enforcement that goes via judicial actors, but it could also be more informal public enforcement. I think the Commission could take cues from the free movement, from general free movement law. So, for instance, when it comes to the free movement of goods, there's a procedure that's called Solvit. It's basically national networks that exist of different actors where citizens and companies might bring complaints. And these national centers then try to solve these issues. So how could this look for Schengen? Well, national centers could be established that include different actors, officials from national ministries, the national ministries of interior, but also national ministries of economy, independent legal experts, and officials from member states most affected by these border controls. And these centers could then try to solve these issues in case of prolonged border controls. I don't see any reason why it should be national ministries of interior alone who should be responsible for deciding on the reintroduction of border controls. The proportionality analysis in the Schengen Borders Code has to include effects on free movement. Ministers of economy would arguably be better positioned to and better equipped to assess the effects on free movement of goods and free movement of services, etc. This would also address a gap that I see currently exists in the current governance approaches that are suggested. And this is the absence of EU citizens when deciding on the reintroduction of border controls in this whole process. The development of Schengen has, since its origins, always been linked to EU citizenship. This is also something that is reflected in the current treaty framework in Article 21 of the TFEU and in Article 3 of the TEU, which makes an explicit link to EU citizens and the area without internal frontiers. So my suggestion would actually be to take this legal text seriously. The last and the third and final point is also when it comes to the legislative proposals that are made. Cues could be taken from free movement law on the reintroduction of border controls. So, for instance, when it comes to the reintroduction of new legislation that concern restrictions to the free movement of goods, the member states, when they want to reintroduce new legislation, they basically have to notify this legislation to the Commission. The Commission, this triggers a standstill period. So the Commission basically then analyzes first this national legislation before member states can apply it. This is a form of preventive control. So how would this look for the Schengen Borders Code? Well, in the Schengen Borders Code, the current twofold approach could be upheld. On the one hand, you would have unforeseen threats. On the other hand, you would have foreseen threats. When it comes to foreseen threats, this form of preventive control could be applied. This means if member states would want to reintroduce controls for foreseen threats, they would notify to the Commission. This would trigger a standstill period, and during which bilateral discussions between the Commission and the member states would be led. Arguably also involving different persons or different actors who might have a strong interest in being represented in and take part in these dialogues. And only after the Commission approves it, member states would be able to apply internal border controls for foreseen threats. I'm aware that this might seem, on the one hand, very far-reaching. On the other hand, if we are to take seriously the fact that Schengen, that the legal and normative core of Schengen is actually free movement law, I don't think that this is far-reaching to actually take cues from other free movement provisions and initiatives that exist. Thank you.
Thank you very much, Stefan. I think that has really woken us up, and these are very interesting ideas. I pass directly on to Mr. Scott for first comments, and like to hear another view, probably.
Thank you very much, and thank you very much for the invitation to come here today to speak about the case of the judgment of the Court of Justice, where I served as Advocate General. I was Advocate General in the court in Luxembourg from 2015 until 2021. And this case, the Schengen case, was the last opinion that I made to the court on the 6th of October. I am put in this delicate situation that I have to explain a judgment from the court that I basically disagree with. But I will try anyway. But I think in order to do that, I think I would start with my opinion and outline what the basic thoughts were in that opinion, and then turn to the judgment and see where that leaves us. Now, I will be honest to you and admit that this case did give me some headaches. Because on one side, you have a fairly clear wording in Article 25 of the Schengen Code, saying that after 6 months, you have to abolish the border control unless there is a new threat. And here it is important to distinguish between a new threat and a renewed threat. A renewed threat is a threat that continues. It doesn't stop at 6 months, it's still there. So if you are threatened with terrorist actions and that stays for more than 6 months, that's a renewed threat. But if you have a terrorist threat and then a migration threat, that's a new threat, the migration threat. The problem basically is that threats do not obey to absolute time limits in the Schengen Code. That's the problem. So on one hand, you have the legislator saying that after 6 months, you can no longer have a border control for the same threat. But it might still be there. And what do you do then? And that's why, and I must admit, I'm quite diplomatic. And it's the first time I have used the word absurd in an opinion, because I think that this rule personally could lead to absurd situations. Nobody disputes that you can introduce border controls for a terrorist threat on several occasions over the years. You can do it this year, and maybe in 2 years, you can have 6 months border control again. So you can do it for more than once in the lifetime of the regulation. Where does that leave us then? Well, if you are at the end of the 6-month period and you can see that the threat is still there and it's serious, it threatens your internal security, maybe even national security, do you then have to open the borders for a couple of days, couple of months, maybe a year before you can introduce it again? And does that seem reasonable if you could maintain the border control if there was just another threat, which might not be the case? So I had a lot of discussions with my staff how we should solve it. At the end of the day, it was my opinion that this absolute time barrier is not in conformity with primary law. And I took Article 72 of the Treaty of Functioning of the Treaty of Functioning of the Union and Article 4 of the Union Treaty that gives member states a right to preserve internal security and national security. And I was, in my opinion, the question was, is Article 25 possible to interpret in the light of primary law? Because if that's not the case, it might simply be invalid. Because I put a lot of emphasis on those two primary law provisions. I found that it was possible to interpret Article 25 in such a way that if you are at the end of the 6-month period threatened still, you have to seriously consider whether it fulfills the principle of proportionality, continue. And here I emphasize that I did not take position on the long Austrian border control. It's a purely interpretation of EU law. It is for the national courts to apply that law and see if the Austrians have had a good reason to continue the border control. That's very important. But in an abstract way, we have to consider that it can be necessary to maintain something if the threat is still there and it's serious. So my opinion was twofold. It could be interpreted in the light of primary law, so we could maintain the validity in principle of this rule. And if you go beyond the 6-month period, then you really have to consider whether it's necessary. And here I mentioned in a footnote that you should see if other means are effective. International police cooperation, for example, police checks in your country, also in border areas, if that could be sufficient. And and that's very important, the Commission's role in this. Because at the hearing, the Commission came and said, together with the plaintiff, that this was not acceptable. The border control was too long. But the Commission did nothing over the years. They did not address this issue to the Austrian government, and I do not hide that I had a few critical questions to the Commission at the hearing. Why are you completely passive over 6 years, and now you come and say it's unacceptable what's happening in Austria? You have to fulfill the role that you have in the Schengen Code. You are required, if you have doubts, to issue an opinion and take action. You are the guardian of the treaty. And I'm pleased to see that the court follows me, at least on that point. So I think it's possible to have a situation, a balance here, where you take, on one hand, into account a 6-month period, and after that 6-month period, you can exceptionally continue if you have a very, very good reason and fulfill the proportionality test. And you have to consider whether this border control is effective or not, because probably not many terrorists are being arrested at the border. I think also that this is in conformity with the judgment in Quadrature du Net on retention of data. And I'm referring to case number C511-18, a referral from the Conseil d'État, where Conseil d'État said basically Tele2 Sverige judgment, where I was also Advocate General, was too strict. We have to loosen it up. We have terrorist threat in France, and we need to apply Article 4 in the Union Treaty to do something about that. And we would like to have the possibility to a generalized retention of data for certain periods. And the court accepted that. And I think that pragmatism is very, very important to strike the right balance. My former French colleague, Monsieur Bott, said, and I will do this in French, to explain the role of an advocate general, he said, le rôle d'un avocat général, c'est d'être la mauvaise conscience de la cour. To interpret that into English, the role of an advocate general is to be the bad conscience of the court. And I think that the court got it right in Quadrature du Net, and I think respectfully that the court was too strict in this case here. So I'm sorry, I'm not convinced by the court's judgment. I maintain my appreciation in the opinion. And I think also that's the opinion of the French Supreme Court Conseil d'État. And I think it's reasonable not to distinguish between renewed threat and a new threat. With a renewed threat, you should be able to continue, but under very, very strict conditions. And the Commission has to play its role. Now, the ECJ, and I can make that very short because it is a very clear and very short judgment, said no. They simply said no. 6 months is 6 months, and then you have to abolish. The court does not give a clear indication of what means a renewed threat. And that's a big problem, in my opinion. Because what happens if you are threatened by a terrorist group that usually use certain arms, weapons, that ceases to exist. But now it's another terrorist group from another country with a complete other threat, with another arm, much more dangerous arm. Do you have to open your borders during that time? Or can you say that that's a new threat or just a renewed threat? I think that is a big, big issue. I'm looking forward to see how that is solved in the Council and the Parliament. Another point I would make regarding the court's judgment is the lack of reference to Article 4 in the Union Treaty. Now, they say that Article 72 cannot be used. It's a very restrictive interpretation, but we have to respect that. That's the Grand Chamber. When the Grand Chamber has said that that's the interpretation, that's how it is. But what about Article 4 in the Union Treaty? We are left with no answer there. And I think because it plays a major role in quadrature du net, we have to think carefully how these new rules should be adopted so they comply with primary law obligations and the right for member states to maintain national security. This leads me to the end. I think that it is now for the legislature to find a new set of rules, and I would urge that it strikes a good and right balance between the fundamental rights here, the right, obviously, for free movement for persons within the Schengen area, and the right for member states to preserve internal security and national security. Thank you very much.
Thank you very much for this very interesting insight. I agree that indeed we are in a situation where we need the legislator to clarify a couple of issues. Before I give the floor to Pierre, I've already introduced you. Before you arrive, just perhaps 2 points also with a view to the heading of our panel. I think, at least as we understand, the current Schengen Borders Code is that, yes, the co-legislators have seen that there can, of course, be a threat that exceeds the 6-month limit. But the assumption is that within these 6 months, there should be a cooperation between the member states that allows the member state to move away from the tool of border control to other tools, in particular police cooperation, as we are mentioning it in the heading. Now, and I guess Pierre is going to give us an insight in that. Does this always work in practice? That is the question that I think we are having now at the moment. As to the new threat, I think, again, from our side, we read indeed the judgment in a way that new threat doesn't mean you have to have one day terrorist threat and the other day secondary movements. No, it's about the real life situation. So in the case that you described, different terror groups in a different setting, while this is all a terrorist threat for us, would be a new threat, because it's a new situation. The country needs to react to this differently, and then to the other situation. So again, we would think that we would need to give them the 6 months to adapt their functioning to this new threat. I think that is within the Commission. I think, unless my colleagues over there now start shouting, I think the general understanding. Okay, with this short comment, I pass on the floor to Pierre.
Thank you very much. And if I understand correctly here, I'm the bad cop, the bad cop reintroducing internal border control. So I hope that you will listen to me anyway. First, I would like to react to the title of our roundtable, a title that I like pretty much: Guards at Internal Borders, or Policemen inside the territory. If I may sum up our French state of mind on this controls issue, what we would like in an ideal situation, what we would dream about, would be first guards at external borders, but effective external border management, and yes, policemen inside the territory. But excuse me if I may appear as slightly provocative, but here we have 2 problems. The first problem is that the current European legislation does not allow us to have effectively policemen inside the territory. I may take only one example because I don't want to be too long, but in the currently enforced Schengen Borders Code, you have an Article 23 called police checks. And this article says that these police checks can be implemented only as spot checks. In French, we say contrôle aléatoire. And this is totally irrelevant in the if I compare this to the way the police is working. our law enforcement authorities needs to make plans. They need to achieve risk assessment analysis. They need to allocate their resources in a proper way, and this cannot be done on a spot check basis. It's the contrary. We should be able to planify, to make plans. This is why of course, we fully support the way the Commission presented the revision of the Schengen Borders Code, including with some response to that specific point, which is a very important point. So my first point is to say, please let us have really policemen inside the territory, and then it will be easier for us to consider our decisions on controls. And my second problem is that, sorry to say, but my fellow citizens are not convinced that external border management today, and I'm not blaming anyone for this. This is a collective responsibility, and I assume that France has also its share of responsibility in protecting the external border. But my fellow citizens are not convinced that today these controls are effectively implemented. So this has nothing to do with national identity building or some kind of fantasies. This is what my fellow citizens think, and my government cannot do anything else than taking this into account. I trust that a new Schengen Border Code, as we have it on the table now, and let me say that we are very happy and proud of what we have achieved together with the other member states within the Council to reach a general approach on this, because this new text is putting forward alternative measures. I mean measures that are not internal border controls, measures that are something different, less, I would say, less coercive, less intrusive, less with less impact on free movement, which is a very important principle we cherish too. And for us, this is the solution. If I may draw a comparison, you may remember that when we had the terrorist attacks in 2015 in Paris, in the Bataclan, in fact, our former president at the time, he made not only one decision about internal border controls. In fact, he made two decisions. The first one was to reintroduce the controls, for sure. But the second one was to, on the internal scene, to activate the state of emergency in France, which is a very exceptional legal framework allowing the law enforcement authorities to take some specific measures for a limited period of time. And in 2017, when President Macron was elected, he very quickly had to face the issue. Should we or not put an end to the state of emergency? And I remember that period because at that time I was a member of the Prime Minister's cabinet, and we had to bring the answer or the possible solution. And if I may share that piece of experience on my side, the only way to explain to our fellow citizens that we would put an end to the state of emergency system, the only way was surely not to say, okay, there is no problem anymore, and we have legal issues and constitutional problems, so let's just quit and stop the state of emergency, and everything will be okay after that. No, this was not feasible, because this was not the state of our public opinion. And let's keep this in mind, because it's always easy to debate and discuss all of these issues in our very interesting Brussels bubble. But at the end of the day, we also have to report to our citizens, to people who are voting, who are experiencing the concrete consequences of our decisions in their daily life. So the decision that was made in 2017 was, first, we put an end to the state of emergency, but at the same time, and with the exact the same timing of entry into force, we passed a law in the national parliament bringing some alternative measures. And that was not only, I think, a positive step on the operational, from an operational viewpoint, because our police services were quite convinced about that. They were very happy with the state of emergency, I have to admit, but they were okay with stopping it, provided that we could bring them different solutions. And I think today, I don't know if we can draw an exact comparison between this situation and our current situation, but I think that this is our duty today, to say, okay, we have to consider that internal border controls cannot be endless, and we are convinced about this. But we have to bring the relevant solutions that may convince our people that security issues, not only migratory issues, but I want to insist on security issues, because this is the real reason why we are reintroducing internal border controls. So we have to show them that the situation is seriously dealt with, because we cannot say that Schengen is only. I know I will again appear as provocative, but Schengen is not only about the absence of internal border controls. That's why I if I may, I very much like your title for the sense setter. I don't like the first sentence of the the introductory paragraph, when you say the absence of internal border control is the key feature of Schengen. It's a key feature. It's one of the two key features, but there is a second key feature, which is a space of security in our common space, including with strong external border management. I'm insisting on this because this is a very challenging debate. This is a very sensitive issue on political level, and here we have to use our both brain hemispheres, if I may say so, not just one, the two of them. So what we try to do during the French presidency, I'm mentioning this period because this was the moment when we tried to build upon the Commission's proposal on the SBC. We tried two things. First, to consolidate and build strong, effective alternative measures, because we really are convinced that the very day we will have these alternative measures, then we will be in a situation to come back to our authorities and say, okay, I think that this is the moment now to take some different decisions about controls. And if I may react to what you said, just to show that I carefully listened to you. You said, I don't understand why only ministries of interior are in charge of this. We should involve ministries of economy and so on. But I want to reassure you, because in France, this is not Mr. Darmanin alone deciding about this. President Macron is making the decision. And please be convinced that he's perfectly making the balance between security issues, European affairs, trade and economics, and I think that he is not hesitating for a long time when he has to make the decision. So that was the first thing we tried to do, thanks to the Commission and to the proposal that was on the table. Yeah, and I will stop there. Sorry. And then the second thing we tried to do was to frame more the rules about internal border control, because we can understand that we need to bring additional rules. We try to enhance the, I would say, gradual increasing pressure of controls, of monitoring from the Commission, with Commission's opinions, and additional justifications that are to be provided by member states for introducing controls. And these justifications are more and more demanding with time going, of course. That's perfectly consistent. And there was a big question about timing, meaning should we put I would say a specific limited duration for controls, like 1 year or 2 years, I don't or not. And our choice, and I want to just to say one word about this, because sometimes I listen to people saying, but you, in your general approach, you said you provided with endless internal border controls and something that is unlimited. But this is not what we did. What we did is to have some periods of time, a sequence of periods of time. And after a certain period of time, there is a last period. There is a last period with duly justified or duly reasoned motivations that are to be put forward. And there is not a specific limitation with a number, but this is a last prolongation. And this is a difficult balance we have to draw. I know that it would be from a intellectual or psychological viewpoint, it would be easier for everybody to say, okay, it's 1 year, and then after 1 year, it's over. But frankly speaking, who in this room who can tell me with certainty that he or she knows about the maximum duration of a threat? I don't know about that, and frankly, you can listen to me as a good sample of the way we are thinking about these issues in France, in the Ministry of Interior, but not only. Our dream is not to have endless controls. We only have one wish, which is not to be deprived from the means to bring a response to national security challenges. And we are not comfortable with the idea that some regulation being drafted in Brussels would say, okay, a threat is 1 year and a final point. This is not how things are working in the real life. I'm sorry to say that. So sorry for being a little bit long. Maybe I have said a few things that are not totally consensual, but at least I try to speak very frankly, and I'm open to questions if there are some.
Yeah, I think that's why you're here, no? You're not here to make consensual statements. And I just wanted to say, I should have told you, no, I didn't introduce you as the bad guy. I introduced you as representative of the former French presidency who managed to achieve the general approach on the proposal. So given that we are already quite advanced in time, I would say we open the floor for questions. And who wants to come forward? Who is at this, not so early hour anymore now, ready to? I see a hand back there, the gentleman, I think.
Thank you. My name is Bodhi Janraj, and I teach at the Central European University. And I haven't had the privilege to listen to all of the morning, but I would address my questions to Mr. de la Motte, asking him 2 questions. One, France announced the reinstallation of the internal border controls, referring to the terrorist organizations present on national territory, targeting the Rugby World Cup taking place in September and October 2023. So in May, they already knew that there will be an increased threat in October because of the Rugby World Cup. If we could hear any details about that, also concerning the terrorist groups which are already present in the territory of France, how will internal border controls restoration diminish the threat by those terrorist groups? Second, could we have any factual evidence showing that the reintroduction of the controls at the internal borders has diminished the number of arrests of terrorists and the threat? Is there any empirical, controllable evidence that the internal border controls had any effect, comparing statistics with periods when there was no internal border control? The two answers would help a lot to sympathize with the French position, and I'm sure you are ready with those answers.
Thank you very much. I fully understand that that two questions. It's not easy. I have to say very frankly that it's not easy to answer because, for instance, for the first question, we are entering a topic where it's not possible to come into details in such a large audience. But what I can say is that the terrorist threat that we presented in our latest notifications is a real one. We had serious reports and alerts from our intelligence services on a repetitive basis, and this is not behind us. That's what I can say. And to come to your second question, which is also fully legitimate, I will never be able to explain you about the attacks that have not occurred. What I know is that every year we are on the basis of these controls, we are putting under arrest hundreds of persons known in our European databases as involved in terrorist groups, and we are blocking them. So I cannot promise that these hundreds of people, some of them who would have committed a terrorist attack. But what I know is that should this have occurred, I know very well who would have been responsible for the failure. So, but I can share with you again, if you don't have it, our latest notification, which and also the notification even before. There are some figures inside. I think quite eloquent about the results with the controls.
Excellent. Maybe we collect a couple of questions, given that we're already quite advanced in time. Back there, number 1, number 2 here, and number 3 back there. Please.
Thank you. I actually have a very technical question, also a little bit based about the variable geometry in Schengen, and so I guess it's best directed to Mr. Salomon. If the Commission were to take infringement action, what would be the legal basis for that vis-a-vis Denmark, given its specific position under the protocol? I was wondering, would that be 258? Would that be the protocol itself? Is there even the possibility for the Commission? I know it's a very technical sort of legal question, but I was wondering, and I discussed it yesterday with some colleagues, and we also weren't entirely clear on that. So I was wondering in relation to Denmark, what would be the enforcement powers of the Commission there? Thank you.
Thank you. I'm Paula García Andrade from Comillas University in Spain. I had a question for Mr. Saunders-Gaard. I was very interested in your position on Article 72 of the TFEU on the reservation regarding the exercise of responsibilities of member states on law and order and international security, and your position on the opinion delivered in NYW case, and in opposition to the restrictive interpretation given by the court also previously in Commission versus Hungary. Does it mean your view means that time limitations or even conceptual restrictions provided by the legislation can be excluded because of those member state powers? Or otherwise, what would be the scope of limitation of national powers that the EU legislature can establish? Does it mean that the legislation can frame those responsibilities but cannot limit them? And whether does it mean, for instance, that this reservation in Article 72 would not allow a complete, in a sense, centralization of border control enforcement? So what's the practical consequences of your interpretation of Article 72? Thank you.
Yes, thank you very much for a wonderful morning panel, which has opened up the debate. Yesterday, we heard that the whole that Schengen has never been stronger. Today, we hear the reality that Schengen is in deep crisis, because if there is one view that tells us that we really need to look at the two logics. I would say that there are more than two logics there. It is really what we hear today and the differing views about what should be done. And I think this is not a consensus, this is a deep dissensus of what is actually happening. And I'm glad this has opened up, and this is a forum to do so. My question relates to all three speakers. I will start with Stefan. I really like the introduction. I'm just in his conclusion. It concerns me if the logic is only to preserve the economic logic of freedom of movement without the necessary component fundamental rights there. I would also be very, very concerned as a practitioner of law and as a person who believes in democracy. So it still is an executive kind of decision to leave it to the ministries of finance or economic to be the drivers rather than introduce the fundamental rights aspect. And the second question relates to the question of the duration of the threat, the question of the duration of the exceptional situation. And this is a fascinating debate that takes us back to the debates of Schmidt and Agamben. And it's fascinating in different ways. But I would argue that what we heard today, particularly by the person, the representative of the French permanent representation, negates the very logic of free movement, because there's always going to be a threat there. So if we push to this logical conclusion their argument, then what we're left with is a situation where let's do away with the whole logic of free movement and the erasure of internal border control, and let's bring back the whole logic. Or in his alternative that he was proposing, it's basically bringing in rules that would substitute the whole logic with forms of control. And I'm sorry, but this is really the negation of the whole logic of Schengen. So I would like a comment on that. Thank you.
Thank you very much. I would suggest you start as Stefan completes, but I look at Professor De Broeke. Do we have afterwards still time for a last round of questions, or rather not?
Well, I'm afraid not, except if they are really very brief, and if everybody does the effort of also answering very briefly.
Well, I will do that then. The first question, the answer to that, what is the legal base to take possible infringement actions against Denmark? I have not investigated that. I don't know if the border control is in violation of the Schengen rules. That's up to the Commission to verify. Regarding the question of Article 72 of the Treaty of the Function of the European Union. You touch right at the core here. That's the delicate problem. As I write in my opinion, I think an absolute time limit is difficult to operate with if you also allow member state, or have to allow member state to fulfill that obligation to preserve internal security. I think it is difficult to reconcile. And may I just point to you an article that was sent to me before this conference that I found very interesting, written by two professors at Université Catholique de Louvain, and it's called for a wiser and effective management of reintroducing internal borders controls, comments on the NW judgment. And here they point out to me in the mail, this is probably the first time somebody is defending the opinion and is critical against the court. So of course I read it with interest. There is a section, and the title gives the whole thing, is a frozen balance between free movement and security interest. A frozen balance. I think that is very precise. Also, my reading of the court's judgment, it's a frozen balance. It does not have this flexibility and pragmatism that I see in other courts' judgments, in particular in the area of retention of data on mobile phones, because it was because of the terrorist attack in Bataclan that the Conseil d'Etat came back and said, well, are you sure we cannot, if we are threatened with terrorist attack, have a generalized system of retaining data? And the court said, yes, you can on with Article 4, but only for a certain time, not an absolute time. And it's up to the national courts to verify if the threat is still there. So I would prefer something where you leave it to a judge to verify, or the commission, whether the criteria is still fulfilled, instead of absolute time limits. But that's for the legislature to deal with.
Well, the short answer to the question raised, I mean, I would have rather answers for the two of you, but perhaps there's still time for this at the end. Well, the short answer to this is, well, the reference to EU citizenship is not about exclusively an economic logic. The point is really about the rights of citizens and the political dimension that is at the core of developing Schengen, that you can see in the origins of Schengen as well reflected.
Great answer. So I can take two more? Very brief. And I realize I have never looked behind me. So, and here we have a gentleman. Okay, and then the gentleman with white shirt. And sorry for everyone behind, but we need to wrap up. And we are at 3. Okay, really brief, please. 1 minute each.
May I start? Okay, thank you very much. My name is Leon Zulig. I'm a PhD student from Gießen University in Germany, and my brief question refers to Monsieur Renaud de la Motte and the incident in last summer, 2022, when Italy rejected a search and rescue vessel to embark on an Italian port. With refugees aboard, and the ship then moved on to France, and as a direct measure, France imposed border controls on the border to Italy, and the French Minister of State for European Affairs even described the border as closed. So my question is, isn't this rather a measure of diplomatic retaliation than a measure of public security? And is this compatible with the Schengen Borders Code?
We go on, please.
Thank you very much. I'm here representing Austria, and of course, Austria also has something to say on this, also because it was in the focus of Mr. Salomon's intervention. I will be very brief and make 4 points. First of all, I can only echo my French colleague. The decision is taken at highest level at the Chancellery. It is a whole of government decision, taking all other areas into account. Secondly, I invite everyone to read the Austrian notifications since the ECJ judgment. They are long, evidence-based, include evidence on new threats, include numbers on how many successes when it comes to human trafficking, migrant smuggling, Obviously, terrorism is a very sensitive area, and therefore no information can be provided on this. Thirdly, operationally on the ground, there is very close coordination with Hungarian and Slovenian colleagues. Operationally, to avoid traffic jams, there are spot checks, so there are no real waiting times worth mentioning. We are also in formal consultations with the Commission and affected member states. Finally, one reference to Article 3 of the Treaty of the European Union, which explicitly links the lack of internal borders to asylum policy and external border controls. And my concrete question to Mr. Salomon is, maybe you could briefly comment on this Article 3 Treaty of the European Union. Thank you very much.
Okay, thanks. It was a bit longer than 1 minute, but okay. Final question back there, please.
Thank you. So I have a question with regard to so-called compensatory measures, and I'm referring to Croatia. We joined Schengen on the 1st of January this year, and the Croatian Ministry of Interior explained that the Croatian territory will be divided into different zones depending on, the extent of security that needs to be ensured and so on. And they insisted on doing compensatory measures, not only at the external borders towards third countries, but also everywhere within the territory. And I just experienced on my own skin spot checks towards Slovenia. So I'm wondering whether, I see spot checks that have just, that apply to Croatia in an equal way, equal reading by the Court of Justice, as to any other Schengen state. So my question is, would anybody say that due to the fact that Croatia now is applying compensatory measures due to the fact that it just recently joined Schengen, that it can do more spot checks than other states? Thank you.
First one, Pierre. Second one, Stefan. Third one, not sure yet, but...
First, I want to apologize because I have the impression that I am responsible for our being very late this morning. So just a brief answer to our colleague, German colleague here. I can confirm that our border with Italy is not closed. I can confirm that the incident that you mentioned is behind us, and we now have a very constructive relations with our Italian friends. We supported together 2 weeks ago the same agreement in the Council on Migration. And we have also a very constructive, a very developed operational partnership at our common border. We have common units, we have common police units, Italian, French, who are working together, with inside these units, French policemen, Italian policemen that know each other and are used to working together. So, politics are like they are. Sometimes there are some words that are said, and but the reality is first that our border is open, and second that our operational partnership is a real one, stamped with trust and effectiveness and friendship.
Friendship is very important indeed. Let me answer first a question that has been asked, second a question that hasn't been asked. As to the first one, yes, I'll keep it short. So the core of the question is basically, and this also relates a bit to what Advocate General Salomon said. So the core of this question is basically there's an assumption that controls are an appropriate means to address long-lasting threats. This assumption I don't share. Member states don't employ road checks internally to address these threats. So why should they introduce border controls? The Schengen Borders Code and EU law and EU primary law sees these controls as last resorts, really as last resorts. So when after 9/11, there were discussions in the Council on how to address, on whether border controls are an appropriate means to address long-lasting security threats. The Council after 9/11 came to the conclusion, no, temporary border controls are not an appropriate means to address long-lasting threats. This shows how much the discourse has shifted. Second, at an abstract level, I see, and this would be the concrete answer to the question. At an abstract level, I see when we look at EU law, a principal choice that has been made by the EU legislator in Amsterdam and in the Treaty of Lisbon, that security measures shifted to the external borders, and that there has been a harmonization of all of these policy fields that Article 3.2 refers to. This is a logic that you see in the Treaty of Amsterdam. This is a logic that you see in the Weissenbeck case, and this is a logic you see in the Treaty of Amsterdam in Article 3.2. The second point, and this is a bit the reference to democratic credentials and what the French citizens really want. Well, I don't know what the French citizens really want. I can just see that the cases before the Conseil d'Etat have been brought by French citizens who obviously do not agree with the decisions by the French president. When it comes to these democratic credentials, something that you see in Austria, but also by the French government, is in order for citizens to make democratically informed choices, it would be curious to see to know about what are the direct costs of these border controls? How much do public taxpayers' money go into these border controls? This is something that is not published by the Austrian government. I'd be curious to know how much the direct costs of the French border controls per year would be. Second, it understands democracy only at a national level. However, the whole point about EU law is that decisions of a national government are democratically justified to citizens of other member states who are affected by these decisions. So, in other words, what the frame of reference is, should be in the eyes of EU law, it's not simply national citizens, but EU citizens.
Stefan, I counted 3 seconds, I have to say. First, perhaps the very last question, and then we really wrap up on the issue of the police controls. I mean, Pierre mentioned it actually. Of course, at the moment where you don't have external border control between Croatia and other countries anymore, you have, of course, many other possibilities of cross-border police cooperation that you didn't have before. In that form, because there was a hard border between these two countries. So I think that is the idea what now needs to be kind of built up by Croatia. I would like to wrap up by thanking all the panelists here. I think we could go on with this forever. You can believe that in the Commission we are having these discussions every day for hours. And but we need to finish, and I apologize to the participants whose coffee break, I think we significantly shortened. And thank you, Professor De Broeke, for the invitation.